Well, good afternoon. It is just about this afternoon, yep, nearly 1 o'clock. So carrying on with the next part of this document that was received by, as I say, by the Court of Appeals exactly 1 year ago, the 14th of October 2019. Just make sure everything's working fine. You know what I'm like, always worried about making sure that everything is okay. Yes, seems to be okay. Also, at the beginning of the video yesterday, I mentioned many thanks to, obviously, Travis for joining me on Sunday, Mill, Billy, and Dr. Siltman on the Monday, and how remiss of me not to mention, of course, Tracy Keogh on the Saturday. So that was Saturday was Tracy, Sunday was Travis, Monday Mill, Billy, and Dr. Siltman, and tonight, I know some of you maybe aren't so much into the music scene, the Scottish music scene, but I'm really looking forward to having a chat with Liam Stewart, whose band has just done a new, their first CD, although Liam has appeared on lots of other people's CDs. Finally, he gets around to doing one in his own name. So looking forward to that chat. That'll be at 8:15 my time. So if you want to tune in for a chat with Liam, Liam's a very, very successful in the competition scene and has been from, I believe, a youngster. Anyway, without any further ado, hi there, Mose and, excuse me, TTM, and I don't recall. Let's get a swig of this. It'll help me to speak Scottish later on when I'm chatting with Liam, I'm sure. At least that's my excuse. Now, let's just look at, do that last paragraph of the previous, of part 6, yesterday's video. And hi, Alice. We left off the iconic only one person committed the crime. Sweaty, in his rebuttal, told the jury it's not a difficult decision that you have to make because everything in this case pointed towards one person, towards one defendant. And it's quite a bizarre thing to say when he knows perfectly well that next month, or was it the month after? I think I'll have to check my timelines. But basically, yeah, he knows that Brendan has got his own trial coming up. So why would he say it only pointed towards one person? I think clearly the problem is that Dean mentioned that there are other suspects in this case. Certainly Bobby is a huge concern to the state, and so should Kratz be concerned, because of course the jury actually asked to be sent all of the testimony by Bobby Dassey. But yes, it's quite bizarre. This points towards one person, towards one defendant. But as I say, I think that's Kratz's attempt to try and distance certainly Bobby, Scott, Ryan, to distance them from the possibility that they're involved. Anyway, moving on. This is where we left off. So, item 2, the defense case. Steve was represented by Dean and Jerry. Steve paid, obviously, from his $400,000 that he got settlement for the civil suit from, supposedly, from Dennis Vogel's insurance, $400,000. It's remarkably similar amount to the $450 that Mark Gundrum was supposed to pay Steve. Anyway, from that $400,000, I believe $160,000 went to Glyn and Kelly, Steve Glyn and Walt Kelly, with $220,000 going to Dean and Jerry, which may sound a lot of money. It's a fraction of what the state wasted in prosecuting the wrong persons. Now, in contrast with the state's 14 expert witnesses, the trial defense counsel presented 7 witnesses in total, only 2 of whom were qualified as experts. They never got to present Dr. Larry White. This is one of the problems you have to bear in mind. Dr. Larry White, we see him, we hear him, never got to testify, was offered by Dean and Jerry to Brendan's lawyers, who didn't bother to go with Professor Larry White. Anyway, carrying on. A, defense forensic evidence. Steve's blood in the RAV4. The trial defense counsel did not have a blood spatter expert, which is quite bizarre because, it's quite clear that they, the squiggle by the ignition, when Dean asks Nick Stolke about it and says, could it be, could that squiggle have been applied with something other than a finger? Absolutely. Anyway, trial defense counsel only offered one source for the allegedly planted blood of Steve, the 1996 blood vial, which was located in an unsecured area of the courthouse. No, what does 4 refer to? No, we'll just read it anyway. 4. In the Dassey opinion, the court references the state's theory that Brendan participated in raping and murdering Teresa with Steve, which contradicts the state's theory in Mr. Avery's trial that he was the only perpetrator. Dassey versus Dittman. In Brendan's trial, prosecutor Kratz claimed that Teresa was killed by Steve stabbing her in the stomach, Brendan slitting her throat, and Steve manually strangling her. Prosecutor Kratz claimed Teresa was killed in Steve's trailer, not shot in Steve's garage. So the 1996 blood vial was the only source, offered one source for allegedly planting the blood. Obviously, this theory excluded anyone but law enforcement from planting Mr. Avery's blood. I suppose that's fair enough, isn't it? That they're the ones that had access to it. Trial defense counsel did not do their own independent testing of the 1996 blood tube. Rather, they relied upon the testimony of Janine Arvizu to try to refute Mark LeBeau. Janine held a bachelor's degree in biochemistry and worked as a laboratory quality auditor. Janine testified that Mark's experiment did not account for the absence of a limit of detection. His protocol was rushed, and no one had attempted such an EDTA experiment in 10 years. Additionally, defense counsel presented Rowley Johnson, the owner of Steve's trailer, who testified that he observed that the cut on Steve's finger was present prior to October the 31st, 2005. The discovery of the RAV4 key with Steve's DNA, defense counsel failed to subpoena the bookcase to demonstrate for the jury the credibility of Sergeant Corbin's description of dislodging the key from the back of the bookcase and having it migrate to the northwest side of the bookcase by Mr. Avery's slippers. Neither did Steve's trial defense counsel have a DNA or trace expert to examine the key. The famous hoodlatch DNA. Trial defense counsel did not have a DNA expert analyze the swab from the hoodlatch to determine if the quantity of DNA was consistent with an individual opening a hoodlatch one time. Trial Defence Counsel did not have a trace expert analyse the hood's latch swab to determine if it had actually swabbed a hood latch. The bones in the burn pit. Trial Defence Counsel claimed the bones of Miss Holbrook were planted in Steve's burn pit, but presented no evidence as to who planted the bones, when, or how they were planted. Dr. Fairgrieve would not offer an opinion as to whether Steve's burn pit was the primary location of the body burning, and admitting that he had only looked at photographs and not examined the actual bones. Teresa's DNA on the bullet. Trial Defence Counsel did not have a ballistics, trace, or DNA expert conduct experiments or microscopically examine item FL. Trial Defence Counsel speculated that because Sherry had contaminated the control sample for FL, she may also have transferred Teresa's DNA onto item FL. Trial Defence Counsel stated that Sherry had Teresa's DNA from the RAV4 cargo area sitting right there on her bench. So you can't tell how and whether Teresa Holbrook's DNA ended up there in the same extraction mechanism. Well, this is also very interesting, isn't it? Third-party suspects. On January the 30th, 2007, the trial court precluded Steve from offering direct evidence that a third party other than Brendan Dassey participated in the commission of the crimes charged in the amended information. Trial Defence Counsel named third party suspects pursuant to Denny, which included Scott Taddock, Andres Martinez, James Kennedy, Charles Avery, Chuck Avery, Fabian, Earl, Blaine, Bobby, and Brian Dassey. The trial court, Willis, found that in the absence of motive, it certainly may be more difficult for the defendant to offer evidence which is relevant and material, connecting a third person to the crime. The court simply finds nothing in the offer made by the defendant that goes beyond the level of speculation. How things have moved since then. Hey, Judge Willis. The trial court did allow Trial Defence Counsel in his closing to mention other suspects that were being investigated by Bert and Ernie. Trial Defence Counsel criticised the investigation of these suspects by pointing out their suspicious behaviour. Trial Defence Counsel named George Zipra, Teresa's ex-boyfriend Ryan, and roommate Scott Blodorn, and Teresa's former married lover Bradley Check, and Teresa's business associate Thomas Pierce. Specifically, Trial Defence Counsel pointed out Mr. Zipra's strange behaviour. When told about the fact that, if she died on my property, it would have been an accident. Words to that effect. The lack of an alibi for Ryan and Blodorn and Mr. Check, and the failure for 4 days of Scott Blodorn and Thomas Pierce to report Teresa missing. On March the 18th, 2007, Steve was convicted following a jury trial of first-degree intentional homicide, contrary to Wisconsin Statute 94001, 1A, and felon in possession of a firearm, contrary to Wisconsin Statute 941292A. The jury found Steve not guilty of mutilation of a corpse. Post-conviction and direct appeal. On August 3rd, 2007, Suzanne Hagupian and Martha Askins, prior post-conviction counsel of the Wisconsin State Appellate Defender's Office, were appointed as direct appeal and post-conviction counsel. On June 29, 2009, they filed a motion for post-conviction relief on Steve's behalf pursuant to 80930, seeking a new trial on grounds that 1. The trial court improperly excused a deliberating juror, and 2. The trial court improperly excluded evidence of third-party liability. Steve's motion, including a claim of ineffective assistance of counsel on the jury issue. On September 28, 2009, an evidentiary hearing was held. On October 29, 2009, a brief in support of Steve's post-conviction motion was filed. On January 25th, 2010, the motion for post-conviction relief was denied by Willis in a written order. There was an appeal from that decision, and that decision was affirmed by the appellate court on August 24th, 2011. Now, this court, in its 2011 opinion, so talking about the appellate court here, aren't we, erroneously stated that Stephen Avery was convicted as a party to the crime of the first-degree intentional homicide of Teresa Halbach. Emphasis added. The party to a crime language was in the second amended information, which the state had to dismiss when Brendan recanted his confession. The information upon which Mr. Avery was convicted refers to the original information and did not have the language party to a crime. It's interesting, isn't it? You know, Kathleen Zellner, whilst obviously doing all she can to help Steve, whenever possible, like Dean and Jerry, and obviously Kathleen Zellner, whenever possible, reminds everybody of the innocence of Brendan. On December the 14th, 2011, the Wisconsin Supreme Court denied the petition for review pursuant to 80810. And just to reiterate, of course, August 24th, 2011, 2 days previously, was when Wiegert got together with Ghan and Fallon and handed back, sorted out from Leslie Eisenberg's report, which remains they were going to hand back. Nope, I've done that a bit too hasty. Let's no, I think I've gone way too far. Yes. Okay. It's a very clever thing to do. And I think we're back where we should be. Yes, here we go. As I say, on December the 14th, 2007, the Wisconsin Supreme Court denied the petition for review, but the bones had already been handed back, which to me is very suspicious of the fact that Fallon and Ghan and Wiegert already knew that Steve's case was done and dusted, that he had finished all his chances for review, and that was it. He was going to spend the rest of his life in prison. Let's just carry on then. Section 4 here. Pro se post-conviction. Obviously, Steve now was left without a lawyer, so had to do everything himself. On February 14th, 2013, Steve filed his first and only pro se collateral post-conviction motion pursuant to Wisconsin Statute 97406. The motion was denied by the most unhonorable Judge Angela Sutkiewicz on November the 23rd, 2015. That's interesting, isn't it? November 23rd, 2015. That is literally less than a month before Making a Murderer came out. It's like 3 weeks. Just over 3 weeks before Making a Murderer came out. Steve claimed that trial counsel failed to A, raise a Sixth Amendment violation regarding Steve's jail conversations with his attorneys, B, suppress evidence obtained by invalid search warrants, C, sever the felon in possession of a firearm charge, D, develop an argument based upon available information that the state had planted evidence, E, strike biased juror Carl Wardman, and F, investigate relevant material issues. Steve claimed that his appellate counsel failed to argue retroactive misjoinder. Additionally, Steve claimed the trial judge was biased, and both the trial and appellate counsel failed to raise the issue of the state commenting on Steve's silence in the state's closing argument. On November 23rd, 2015, the court denied all of the claims in Steve's motion as lacking any merit. Where have we heard that before? Steve filed a notice of appeal on December the 3rd, 2015, 12 days before Making a Murderer came out. Let's look at this next paragraph, V, and then I think we'll leave it there for now. The motion for scientific testing, 97125, 97407, and second post-conviction, 97406. Cue the fanfare. Steve obtained current post-conviction counsel on January of 2016. I'm reminded of my wife's reaction when we watched the Dream Killer documentary, and I hadn't mentioned that Kathleen Zellner represents Ryan Ferguson in that case. And of course, when Kathleen Zellner gets introduced into the documentary series, she was amazed. Of course, we haven't seen Kathleen Zellner in action during this case, but we've seen her in plenty of others. Anyway, let's carry on. On August 26th, 2016, significantly, it was just after August 26th that Herman stopped speaking to me. He wouldn't take any more calls. He knew trouble was brewing. On August 26, 2016, current post-conviction counsel filed a motion for post-conviction scientific testing pursuant to Wisconsin statutes 97123 and 97407. Yes, the ones here. On September the 12th, 2016, the appellate court granted current post-conviction counsel's motion to stay Mr. Avery's appeal and remand the case to the circuit court, which entered an order on November the 23rd, 2016, for specific items to be tested. Pursuant to that order, scientific scientific testing was performed, and current post-conviction counsel filed a motion for post-conviction relief on June 7th, 2017, and also filed a motion to dismiss Steve's pro se appeal, which was pending still with the appellate court. That motion was granted on July 24th, 2017. On September 18th, 2017, Steve's current post-conviction counsel reached an agreement with the state to allow the June 2017 motion to be amended without opposition to add and remove claims and for additional scientific testing of evidence. Scheduling for a potential evidentiary hearing in the spring of 2018 was discussed because both sides believed the circuit court would grant an evidentiary hearing on Steve's claims. On October the 3rd, 2017, prior to the state working out the logistics of the RAV4 testing, the circuit court issued an order summarily denying Mr. Avery's June 7, 2017 motion for post-conviction relief without ordering the state to respond to Mr. Avery's motion or granting an evidentiary hearing. On October the 6th, 2017, current post-conviction counsel filed a motion to vacate the October 3 order, informing the court of the September 18 agreement between Steve's counsel and the state for additional scientific testing and an amendment to current post-conviction counsel's motion for post-conviction relief. When Angela did not timely respond to current post-conviction counsel's October 6 motion to vacate, current post-conviction counsel filed a motion for reconsideration on October the 23rd, 2017, and several supplements thereto on October the 31st, memorable date, November the 1st, 2nd, 16th, and 17th of 2017. The motion to reconsider and its supplements contained new evidence that developed after the June 7, 2017 filing and after the filing of the original motion to reconsider on October the 23rd, 2017. On November 17th, 2017, current post-conviction counsel filed a timely notice of appeal from the October the 3rd order. But Sutkiewicz did not rule on the October 6, 2017 motion to vacate until November 28, 2017, when it denied current post-conviction counsel's motion to vacate the October 3rd, 2017 order, its motion to reconsider and its supplements. So, current post-conviction counsel filed an additional timely motion of appeal, notice of appeal, on November the 30th, 2017, from the Circuit Court's order of November 28th, 2017. Then on May 18th, 2018, current post-conviction counsel submitted a motion to supplement the record on appeal with a CD disclosed for the first time by the state on April 17th, 2018, which current post-conviction counsel contains impeaching and or exculpatory evidence. The appellate court remanded to the circuit court to conduct any necessary proceedings and enter an order containing its findings and conclusions within 60 days after the supplemental post-conviction motion is filed. On September the 6th, 2018, after this court's deadline for decision had elapsed, the Circuit Court, without conducting any proceedings, denied all motions submitted by the defendant on or after July the 6th, 2018. She really is, Angela, some piece of work. She's not just, she is saying to the Court of Appeals, you're wrong. I know better than you. Or, more likely, I have people I need to protect. I'm going to try my damnedest to obstruct any kind of justice to help my friends in law enforcement. On January 24th, 2019, current Post-Conviction Counsel submitted a motion to the Appellate Court to supplement the record on appeal with an undisclosed police report dated September the 20th, 2011, which, according to Mr. Avery's current Post-Conviction Counsel, reflects law enforcement's transfer of multiple human bones from the Manitowoc County gravel pit to the Whiting Funeral Home for return to Teresa's family. Steve alleges that the state violated its statutory duty to preserve evidence, and the actions violated Steve's constitutional due process rights. On February 25th, 2019, the Appellate Court, Paul Riley, granted the motion and allowed Post-Conviction Counsel to file a supplemental post-conviction motion. The Appellate Court further ordered the Circuit Court for a second time to conduct any proceedings necessary to address the claims raised in the supplemental post-conviction motion and to enter an order containing its findings and conclusions. But once again, as we know, on August 9th, 2019, the Circuit Court, without conducting any proceedings, denied the motion, finding that the defendant has failed to meet his burden to establish that Wisconsin Statutes 968-205 was violated or his constitutional rights were violated under the provisions of Youngblood. Mr. Avery now appeals. So, we look forward to argument coming next. We're at page 48 of 150. I'm going to say cheerio, and we'll catch you all at a later time. Hi, Dr. Siltman, Sherry, Shane, Claire. Let's see who else have we got here today. Shane, Dr. Siltman, Millbilly, hi Millbilly, and Kelly, hi Kelly, and Alice. Excellent. That's everybody. And Sean. Kelly, Sean. Yep. I don't recall. Hi there. And Hugh. Oh, hi Hugh. Yes, exactly. Brewer bricked, moonlit, nicked. Shane, Millbilly. I don't recall. Anthony. Hi Anthony. Alice. TTM. We've got everybody. Yep. So thanks for having a read through with me. As I say, if you're around tonight, 8:15, looking forward to, as I say, chat with Liam. Very, very successful in the accordion competition world. Has been for a long time, since being a junior. So please join me for that if you can. If not, catch you next time. Bye for now. Let's just close that. See you later. Bye for now.